Dear students, today we take up for discussion American Realism. The emergence of realism in jurisprudence contributed to the growth of skepticism towards law and its administration, and accordingly subjected law to realities of social life. It is an interesting development in juristic thought during 1930s, with a group of legal scholars styling themselves as realists. No myths and preconceived notions are accepted by them and seek fidelity to stern realities. Realism is antithesis of idealism, and accordingly the realists desired to be realistic at all costs. The realists do not claim any membership to any school of jurisprudence. It is not possible to classify them as a school. At best, it is said to represent a movement. There were two kinds of realist movements. One was the American realist movement and the other was the Scandinavian realist movement. Patton calls realism as the left wing of the functional school. It is the study of law as it works and functions. Like sociological jurisprudence, the realism also pointed out the gap between law in books and law in action. American realist movement. The American realist approach to law is partly analytical and partly sociological. To the extent they considered law as it is, without reference to ideals, their approach resembles analytical positivism. To the extent they examined law as a product of social forces and evaluated law by its effects on society, their approach is sociological. According to American realists, law is the product of judicial determination. Moreover, law is not what the judges say it is. Law is what the judges actually do in deciding a case. Law is uncertain until it is decided by judicial action. The judgment in its turn is dependent not merely upon the statutory rules, but also upon such other factors like whether the judge is liberal or not, the influence of socio-economic political forces, and even corruption, and general state of health of the judge and his partiality for the opposite sex, etc. The theory of legal realism, like positivism, looks on law as the expression of the will of the state, but sees it as made through the medium of courts. Law, no doubt, is the command of the sovereign, but the sovereign to the realist is not the legislature, but the court. The term American realists serves to describe a number of American legal thinkers who share the view that the law consists of the pronouncements of the courts. Oliver Wendell Holmes, Gray, Cardozo, Llewellyn, and Jerome Frank were the chief exponents of the American realism. Justice Oliver Wendell Holmes is considered to be its spiritual father. Factors led to the growth of American realism. Several factors contributed to the prevalence of this realistic approach to law in the United States. Selection and appointment of judges. Election or selection of judges and their appointment is a part of political process. In many states, judges are elected to office by popular vote, and accordingly, decisions are likely to be influenced by political considerations. Judges are not free from politics nor above the politics. Power of judicial review. The organization of the judicial system in the United States also played its part. The Supreme Court is the final authority not only to interpret law, but also to decide its validity. In the famous case of Marbury versus Madison, the Supreme Court of United States said, "It is emphatically the province and duty of the judicial department to say what the law is." The U.S. Supreme Court has the power of judicial review, whereby it can declare void any statute or federal legislation if it is contrary to the Constitution. In fact, the power of judicial review was exercised in a number of cases holding statutes or statutory provisions unconstitutional. Multiplicity of jurisdictions. The existence of separate state jurisdictions caused a multiplicity of laws and decisions. Multiplicity of jurisdictions resulted in conflicting or inconsistent judicial decisions on the same subject matter. Flexibility in judicial process. Judicial interpretation or application of legislations to particular cases in which the courts give different meanings to statutory words or language. Judicial interpretation of Constitution. With the changing times, new generation of judges interpret the Constitution differently, departing from earlier interpretations. For example, in Dred Scott versus Sandford, often referred to as Dred Scott's decision, the United States Supreme Court held that the U.S. Constitution was not meant to include American citizenship for black people, regardless of whether they were enslaved or free, and so the rights and privileges that the Constitution confers upon American citizens could not apply to them. In Plessy versus Ferguson, the United States Supreme Court upheld the constitutionality of racial segregation laws for public utilities as long as the segregated facilities were equal in quality, a doctrine that came to be known as separate but equal. In Brown versus Board of Education, the same Supreme Court ruled that United States state laws establishing racial segregation in public schools are unconstitutional, even if the segregated schools are otherwise equal in quality. All this happened without any amendment in their constitution. The U.S. Constitution would remain the same, but new generation of judges gave new interpretations. Scientific prediction of judicial decisions. Schubert, professor of political science at Michigan University, proposed the application of scientific techniques of prediction using computerized techniques to the task of predicting the outcome of judicial decisions. Schubert draws attention to the success of Rodell's scientific forecast of the outcome of Baker versus Carr, a case heard and decided in the year 1962 by the U.S. Supreme Court. A similar success in Gideon versus Wainwright was achieved by Lawler, a practicing lawyer and computer scientist, in the year 1963. Thereafter, this exercise was carried on in a number of cases successfully. Schubert, in his judicial analysis and voting behavior, enumerated the personal factors likely to influence judicial decision as remote and indirect factors, such as the judge's education, social position, personal and family associations, etc. The direct factors, such as the judge's legal and political experience, opinions, traits, etc. Gray, an American jurist, considered that law is not an ideal but an existing thing. He regarded statutes only as one source of law and declared law to be what the courts lay down as rules of conduct for the observance of the people. He denounced it as childish fiction to say that judges do not make laws but only state the law as it is. According to Gray, law is not laid down by the sovereign but by the courts. The ultimate criterion to judge whether a rule is law or not is its enforcement by the courts. He said, law made by the legislature is probable law, whereas law declared by the court is real law. Law enunciated by legislature loses its force if the court denies its validity. Law enunciated by legislature binds the people if the court rules so. He went on to say that even earlier decision is not law, it is a source of law. Gray prepared the ground for more skeptical approach. Holmes realism. A much more version of legal realism is that which originated with Holmes and which has wielded enormous influence in the United States. This is the theory that all law is in reality judge-made. Holmes begins by considering the situation not of the judge or lawyer, but of what he calls the bad man, the man who is anxious to secure his own selfish interests. In order to know the true nature of law, we must look through the eyes of a bad man. What such a person will want to know is not what the statute book or textbooks say, but what courts are likely to do in fact. Holmes said that the prophecies of what the courts will do in fact and nothing more pretentious are what I mean by law. But what the courts will do in fact cannot necessarily be deduced from the rules of law in textbooks or even from the words of statutes themselves, since it is for the courts to say what those words mean. As Gray observed, the courts put life into the dead words of the statute. Question of law could not be answered by purely logical inference. They must be decided by reference to social, moral, political, and other factors. As Holmes remarked, the life of the law has not been logic, it has been experience. Even before Gray spoke, Holmes had expressed that the emphasis on the concept of law must be in judicial declaration rather than in legislative enactment. The court may accept statute as good law or reject it as invalid. In this view, an enactment can only be said to contain the probable law, meaning thereby the law which the court may very probably declare as valid, but carrying no assurance that it is real law. But to say that until a court has pronounced on a matter, there can be only probable law, but not real law, is an exaggeration. Even when a matter is covered by a judicial decision, there is no guarantee that another case of the same type will be decided in the same way. Overruling and dissenting decisions are not so rare as to be ignored. Today, as we are living in the era of codified law, it may be thought that the creative days of the judges are largely past. It is also said that even though in modern times law is more and more statutory in nature, still the days of judge-made laws are not over. In fact, for the courts, the necessity of choice still remains. Legislation is concerned with the general, judge with the particular situation. Legislatures use words for general application. Judges see whether the case falls within the framework of those words, and if not, whether an extended or restrictive meaning should be given to those words. Though the legislatures could enact rules that were absolutely clear in application, but they could not foresee every possible situation that may arise. So, legal uncertainty is counterbalanced by judicial flexibility. Therefore, law in practice must differ from the law stated in statute. Where courts must choose between alternatives, much will depend on the personality and background of the judges. A conservative-minded judges may differ with a progressive-minded judge. For example, a statute may provide contributory negligence as a complete defense to an action in torts in cases of road traffic accidents. Yet, the sympathy of the judge for the plaintiff and antipathy towards the defendant's insurance company may lead to the end result that contributory negligence will for the most part become a defense in theory only. Therefore, realists said that a statement of law is nothing more than a prediction of what the courts will decide. This is what a lawyer does when advising a client whether or not to bring proceedings. A lawyer, out of his knowledge of the law and his experience in the courtroom, estimates the chances of success and assesses the amount of damages likely to be awarded by the court and advises his client. A textbook writer who expounds the rules of law which have been made examines the practice of the courts in applying them. There is an element of truth in the arguments of realists. The distinction that the realists draw between law in the books and law in practice is a valid one. Realist contribution is used in legal theory to highlight the creative role of judiciary to debunk the slot machine deductions, to provide solutions to legal problems, and to show that the decisions often involve complex problems. Levelin's realism. Carl Levelin has been a professor of jurisprudence at Columbia and an important thinker of realist movement. According to him, realism is not a philosophy but a technology. In his article, Some Realism About Realism, he enumerates the basic common points on which all realists seem to agree. They are: law is not static and should be considered and investigated as if in flux. Law is to be considered as a means to a social end. Society is in a continuous process of change and is in a state of even faster flux than the law. Therefore, continuous re-examination and revision of the law is essential. Ease and art must be divorced temporarily for the purpose of legal study. The jurist should look at what courts officials and citizens do without reference to what they ought to do. Traditional legal concepts and legal rules cannot provide a full description of what the courts do. Law has to be evaluated in terms of its impact and effects on society. Levelin says jurisprudence must expand its ken beyond the rules of law to consider the techniques of their application. He said that the legal research should be shifted from the study of rules to the observance of the real behavior of law officials, particularly the judges. The most significant aspect of Levelin's contribution to realism is his functionalism. He perceives law as serving certain fundamental functions called as law jobs. He has identified 6 law jobs. They are: adjustment of trouble cases, preventive channeling of conduct and expectations, preventive rechanneling of conduct and expectations to adjust to change, allocation of authority and determination of procedures for authoritative decision making, provision of direction and incentive within the group, and the job of the juristic method. According to Levelin, the most important job the law has is the disposition of trouble cases. In one of his major works, The Bramble Bush, he said, "Disdoing of something about disputes, disdoing of it reasonably is the business of law, and the people who have the doing in charge, whether they be judges or sheriffs or clerks or jailers or lawyers or officials of the law, what these officials do about disputes is, to my mind, the law itself." Frank's realism. Jerome Frank was the most radical of the American realists. He was a practicing lawyer, a judge in the United States Circuit Court, and also visiting professor at Yale Law School. Law and the Modern Mind contains Frank's jurisprudential thought on realism. In this work, Frank makes an attempt to demolish what he calls the basic myths about law. According to him, certainty of law is a basic myth. He questioned the basic myth that judges do not make law, they only discover it. Frank observes that law could not be separated from the decisions of the courts. Hence, it was necessary to understand the basis of judicial decisions, and this required an investigation of a variety of factors, often of an irrational nature such as emotions and hunches. The law is, in relation to a set of facts, a decision of the court relating to those facts. Until the court has given its decision, no law concerning those specific facts is in existence. Before the making of such a decision, the only relevant law available is a lawyer's opinion out of his guesswork as to what the court will decide. Frank said, "No one knows the law about any case or with respect to any given situation, transaction or event until there has been a specific decision in the form of judgment, order or decree with regard thereto." Frank asserts that the law is essentially uncertain. Rules are no more law than statutes are law. Rules are mere words, and it is for the courts to indicate what rules mean. Rules are not to be found at the basis of a judge's decisions. Those decisions may be arrived at before a judge finds a reason for them. The reasons he gives later may be no more than a rationalization of his intuitive feelings. Frank believes that a judge may start with conclusions and work back to suitable premises, and in this way judge feels or hunches out his decision. Frank observes that the knowledge of the rules alone is of limited value in predicting the outcome of a trial. It is necessary to turn out for guidance to a study of other matters. Thus, the prejudices of judges may be significant factors affecting the outcome of legal proceedings. He observes that a judge's decisions are the outcome of his entire life history. His friends, his family, vocations, schools, religion, economic background, political ideology, likes, dislikes, etc. are influential factors. In fact, judge is unaware of his prejudices. According to Frank, the courtroom, not the library, should be our laboratory to study the law in action. The fact-finding process in the trial courts is the key factor in the administration of justice. Frank observed that there is an element of uncertainty in the determination of the facts by a trial court. Frank probed into innumerable sources of error which may enter into a determination of facts by a trial court. There may be perjured witnesses, coached witnesses, biased witnesses, witnesses mistaken in their observation of the facts to which they testify, missing dead witnesses, missing destroyed documents, crooked lawyers, stupid jurors, trial judges who are stupid or bigoted or biased. The main thrust of Frank's attack was directed against the idea that certainty could be achieved through legal rules. This, in his view, was absurd. If it were so, he argued, why would anyone bother to litigate? Even where there is an applicable rule, one of two opposite conclusions possible. How does a judge arrive at this conclusion? He does so by a hunch as to what is fair and just or wise or expedient. The lawyer's task then is the determination of what produces the judge's hunches. The personality of the judge and the judicial hunch are not and cannot be described in terms of legal rules and principles. Frank argued that law is uncertain. Paper rules do not produce legal certainty. Law cannot be separated from the decisions of the courts. It is necessary, therefore, to investigate the factors which enter into the making of a decision. Knowledge of the rules is of limited value in predicting the outcome of judicial proceedings. American realism, as Hunt pointed out, is powerfully informed by a behaviorist view of law. This behavior orientation is evident in the works of all the leading exponents of the realist movement. The behavioral psychology is concerned principally with judicial behavior. American realism is a method of the application of psychology to the sociological study of law. Drawbacks of American realism. Realism, like other theories, has many drawbacks. The realist movement can relate only to a system that concedes large power and wide discretion to the judiciary, including the power of judicial review, even to strike down legislations as invalid. A totalitarian system wherein judiciary is subordinate to the administration affords no room for realists' view. Theoretically, it is possible to conceive of a state where the courts are completely free to decide any point as they wish and resolve each dispute on its merits. But in that state, no man could ever say what the law was. One could only predict what the judges might do. But this is not the position in ordinary legal system. The judges are the discoverers of law, but not the creators. Secondly, statute is law as soon as it is passed. It need not wait for judicial recognition from the courts before becoming entitled to the name of the law. In fact, statutes are recognized by the courts because they are law. It is not judicial recognition that makes them law. Thirdly, the realists forget the fact that the judicial decisions creating new law represent only a fraction of the total body of law. Law is so certain that a great number of disputes never reach courts, and even in disputes which go before the tribunals, the major part of law is certain, clear and settled, and is automatically applied. Fourthly, the uncertainty of language, which no doubt exists in some cases, is not an universal malady of legislation. For the most part, language is certain. Comparatively, it will be only in very few cases that we shall have anomaly arising because of language. The fact that a country's boundaries are unclear means that uncertainty will arise concerning borderline territory, but not that all that land within the territory and all outside is in dispute. And lastly, most of the layman's activities in private, commercial and industrial life is undertaken without legal advice. People act according to law as they understand it. To see what the law is then is to discover the rules which actually govern our lives, and for this we must not only look to the judicial practice which the realists emphasize, but also statutes of the legislature and the rules made thereunder by other bodies. This lesson is an attempt to evaluate the contribution of American realists to legal theory and its impact on the legal practice. Thank you.